I'd like to revisit our discussion on Tuesday about the characteristics of the internet that justify government regulation. And Aaron, the more I thought about it, the more flabbergasted I was that so many of you thought that because we all can be publishers, because it's so easy to get online, because there are no barriers to entry, and so on, that justified government regulation. There's so many irresponsible users out there that there was a need for government regulation. So can I ask you what kind of government regulation would be appropriate? Yeah, that's you. Sorry to catch you, ambush you on that, but you must have given it a lot of thought in the last couple of days after you exposed yourself.
I just think that society, that people do stupid things, especially. Okay, I didn't do this, but from the class I was talking about on Tuesday, about the internet. One of the basic features, and somebody else talked about on Tuesday, one of the basic features is that on the internet, nobody knows your tongue. There's a high level of anonymity, and when people don't have their face or their, their character, their name attached to themselves, they just look at it, and that's something that I feel like needs to be governed, needs to be regulated by government.
Fair enough. Eloquently put. Now, what does the government do about that?
That's not. You know, all I'm saying, the other part is, and this was what on Tuesday too. Like the internet is a global thing. Who's going to regulate it, right? It's if you try to enact a law in one country or in one state, that law goes in another state, or is it going to work out? So it's a catch-22. While we do need to regulate it, how will it?
So it's impossible? Do you guys get evaluation forms over this one? Kelly?
Totally agree with you. And then when you ask the question of like how are you regulating it, that's when like the problem comes in. And I don't think there is a solution besides like telling your kids like, oh, don't go meet like dogs, you know. Like, and then it's not something that people do. Like, you know, I don't see
Sam?
Maybe I take a little bit more liberal view of it, but I would say that it's not necessarily what needs to be regulated, because I think regulations we have in place, you can't put child pornography or whatever, things like that are already banned as normal speech, they're not protected. I think those are the things you can protect online. I just think regulations we need are some sort of framework for letting government actually find and deal with these things. Because you don't have content publishers like you do with traditional media, there needs to be more government agencies to cancel these things that are already forbidden, not additional forms of speech or tradition. There's a way to stop things that no, you can't do this.
A new government agency to police the internet.
Well, I think the FBI is going to do that, but it's obviously a new agency. We need more government agencies. We're going to be the FBI and not police, publishers.
The solution is more government, not less. That's not Mitt Romney's platform, but I'm not clear whether we need any more laws. Do we need some law that says, here's what cannot be done? Oh, you millions and millions of users, you can't do that. Won't work. Because it's impractical or because it's not needed? I mean, if you were philosopher king and in charge of the whole thing, by fiat, you can get it through Congress, whatever you want, what would you do to regulate the internet? Somebody over here.
I think it's nice that people are regulated, whether it be on television or whether they can access online. And then, if children can figure that out, at that point, I think that it doesn't matter how much they're restricted. If kids are so light, like they're going to see things on the internet, all over the place. Actually, kind of, I don't know, it's so hard to do that stuff. And I feel like things always come through the internet for you when you're restricted. It's like, I don't know, just kind of a hard place to restrict with laws. So that I think if people can do it themselves, that's probably the best way to do it. And then
No law, anarchy.
well, I guess that we already have some laws in place. I think there's sufficient.
It's hard, isn't it, to draft a law, to write down the language, being precise, because this is, after all, we're in the arena of the First Amendment, so you must be precise about what speech is permitted and what is prohibited. And I think it's very difficult to write a law that would deal with the kinds of problems that obviously do exist. You got one?
I just think I don't see any logical reason for the internet to be more restrictive than say print. I feel like obscenity is already broad enough to encompass the real problem that people have with the internet. People don't seem to be worried that it's going to, for some reason, people don't seem to be thinking that the internet is going to incite people to violence. They're just concerned that minors are going to be exposed to something obscene. So obscenity is already pretty broad. I'd say it's too broad. I think that's good enough to regulate anything that someone has a problem with.
Well, that obscenity only governs sexual material. And gee, there's lots of other things to be concerned about. I mean, jihadist sermons that incite people to attack embassies and attack Americans, fraud of all kinds going on, bullying of all kinds. It's more than sex. The problem is broader, Robert.
Yeah, I apologize for repeating this too early because you get a space that thrives on non-regulation and how it developed with free thinkers being able to collaborate and build this platform that is so ubiquitous now. As for things like we're talking about I think enforcing current laws in that space that can be enforced is the way to go. And the thing about the internet is that it's a place where more speech is going to happen no matter what. So I'm going to take care of this and everything. As for stupid things that stupid people say to you, sometimes that's a good thing.
Sometimes what?
Sometimes that's a good thing. Not that it's work out.
You certainly don't want a law that outlaws stupidity. We need stupidity, do we not? Well, well, the question is, should it be protected?
I feel like going off what other people said, I think the obscenity thing is broad enough that I don't see what else you would try to regulate unless you're going to have different things regulated on the internet versus.
Alex?
I think something that problematizes the issue is the social or the human component of who will actually be doing the regulation. Because right now, on social networks, there are already terms of user agreements that restrict certain types of content, and the corporations outsource the monitoring of all content in everyone's feed. And like I think a lot of people there reason for having psychological like abuse victims because of all of the really explicit and horrific things they have to see and flag and remove. So if we're going to establish a new governmental agency to monitor it, there's actually going to be like human eyes policing all this content. So we have to, really take into consideration.
That's maybe the cure is worse than the disease.
Yeah.
The filters, have come up as a solution for at least some of the problems, including sexual content. It's a paradoxical situation with the library case where the ACLU was saying that filters are completely ineffective and inappropriate, but the ACLU said in the COPA case, in the harmful to minors case, that filters are the solution. They are a less restrictive means of protecting the government's interest, less restrictive than criminal prosecution. But it was the government had it flipped. The government argued that filters are effective in the library case, in the SEPA case. Filters they do the trick to keep the dirty stuff away from minors. But the government argued that filters are ineffective, useless in the COPA case, in the harmful to minors case, and that they need criminal prosecution to govern the problem. So both sides of it have seemingly flip-flopped. And the only player in this scenario who has been consistent is the court, with the court saying in both the library case and COPA that filters are effective and a reasonable means of screening material that might contaminate America's youth. The ACLU, to their credit, or in their defense to the charge of flip-flopping, has harmonized its position. The lawyer for the ACLU, Ann Beeson, said that the real question here is whose finger's on the mouse, the government or the parents? When a parent installs a filter that keeps a kid from seeing a bunch of sites that may or may not be pornography, that's parenting. When government forces all adults and minors to use filters, that's censorship. The whole basis for all of these regulations of the internet that Congress has attempted is to protect America's children from exposure to this harmful material. And as I said, the court has been too willing, in my view, to accept the government's adopting as a compelling government interest the need to protect children. The court simply assumes that there will be harm to children without any evidence that there is actual harm. And since Congress thinks there's actual harm, shouldn't they have to document that, have hearings or something that demonstrate how children are adversely affected by exposure to dirty words or dirty images and so on? After all, what animates Congress here is the supposed harm to children, not offensiveness. With obscenity, what the law protects against is offensiveness, not harm. The government does not contend that obscene material harms people. It's rather that it's unacceptable in a civilized society. It's offensive. The problem with having the government say that we need laws to protect children is that there's no limiting principle for that, and allowing the government to regulate speech in the name of protecting children allows them to regulate all kinds of speech, not the speech of children, but of adults in the name of protecting children. And if you use the government's logic, what's to prevent government from enacting a Literature Decency Act or a prohibitions on the depiction or description of violence, whether on television or in books? What's to prevent government from enacting laws against profanity? We don't want our children exposed to profanity. Or Facebook. Maybe the government decides that Facebook is polluting America's youth. And to protect the kids, we have to have a law prohibiting Facebook. Or bad grammar. When kids exposed to bad grammar. The trial judge in the COPA case and the harmful to minors case concluded his opinion. He's reluctant to declare the act of Congress unconstitutional. But he said, perhaps we do the minors of this country harm if First Amendment protections, which they will with age inherit fully, are chipped away in the name of their protection. There's another law that Congress enacted. I hate to add to your alphabet stew. We had the CDA on indecent speech on the internet, COPA on harmful to minors, SEPA on library filters. Now we have CPPA. It's the virtual child pornography law that Congress enacted in 1996 that deals with child pornography. And as I said before, pornography is not a legal term at all, except when used with regard to child pornography, and it simply means images, pictures of children engaged in sex. And for decades, the Supreme Court has ruled that images of child pornography can be outlawed, are a category of speech just like obscenity, that have no First Amendment protection at all. And the images do not have to be legally obscene. That is, government, both state and federal, can prosecute possessors, sellers, distributors of child pornography without having to prove that the images are obscene. If they are simply images of children having sex, that's enough to make them unprotected and illegal. And the rationale that the court adopted for making child pornography so toxic, so legally toxic, is that children are harmed in the production of the pictures. That is, the production of child pornography is itself child abuse. Children are necessarily abused in the making of the images, and that justifies outlawing the images, even though they may not be technically obscene. Well, then comes the internet, and Congress in 1996, the same year they enacted the Communications Decency Act, passed the Child Pornography Prevention Act, and it made it a federal crime. It amended the federal child pornography statute to make it a crime not just to have images of children having sex, but images of what appear to be children having sex. And that could sweep fairly broadly. That is, it would include young-looking adults, for example, in movies like Lolita and Traffic and American Beauty, where the actors are very young-looking but happen to be adult, and would make the sexual images in those movies, even simulated is enough, that would make those movies child pornography. But when the constitutionality of the law was challenged, as it was in several parts of the country, the government took the position that the law really was intended only to target computer-generated images that the government asserted are, quote, virtually indistinguishable from pictures of real minors. That is what the government was after, with images generated without using any kids at all. Simply computer-generated images. I don't know, do you, whether it's possible to generate by computer without use of a human being an image that is virtually indistinguishable from a real person? Is it, Catherine? Looks like a model, but are you fooled? Do you think that's a real person? Oh, you do. And they don't use in the production of the image any human being. It's not like they pick a picture of a human being and doctor it. Even the hair looks absolutely real. Right. The composites, I can understand that. But that's starting with pieces of real people, not from zero. Okay. Well, I'm just wondering whether the government's assertion was based in some technological truth that it's possible to create an image of what appears to be real children without using any real children at all. Sam? But now it's possible? 16 years, that's a whole eon, isn't it? I don't know, is this so this is a famous photograph that you've probably seen before? Right? And everybody knows who this is, right? I mean, Elvis Presley was actually there, shaking hands with President Nixon. It actually happened. What do you mean it's not Elvis Presley? A friend of mine who's a graphic designer did that to show me how people could be fooled when I asked him this question. And he says no. This was last year. He said it wasn't possible to create an image that was virtually indistinguishable from a real person from scratch, and that the hair was the most difficult part to get right. Well, as I say, the CPPA, the child porn law, was challenged as unconstitutional. And the government argued that computer-generated images had to be treated as child pornography, even though no children were used in the production, because the images might whet the appetite of pedophiles, and the images might be used as a seduction tool. Show kids, hey, look, check this out. Doesn't this look like fun? Why don't we try it? And the government thought that those dangers justified the appears to be statute. And the law was challenged in several parts of the country and upheld several places, except in the Ninth Circuit, where a challenge was brought by a group called the Free Speech Coalition, an umbrella organization of adult entertainment businesses that included a publisher of nudist books, a painter of nudes, and a photographer who specialized in erotic images. And the Free Speech Coalition actually won in the Ninth Circuit, and the law was declared unconstitutional. The government, of course, took it to the Supreme Court, which ruled on the case in 2002. It's another Ashcroft case. That's the Bush Attorney General, John Ashcroft, but it's Free Speech Coalition this time instead of the ACLU. The Supreme Court affirmed, agreed that the law was unconstitutional on its face in a remarkable opinion by Justice Anthony Kennedy. The court rejected the government's request that the law be narrowly construed, that is, read narrowly, so that it prohibited only computer-generated images. The court said, well, look at the language that Congress enacted. It says pictures of somebody, something, that appear to be of children, and that clearly covers young-looking adults. It also covers, according to Kennedy, a Renaissance painting depicting a scene from classical mythology, Hollywood movies like Traffic, American Beauty, Lolita, and so on, a psychology manual, a documentary depicting the horrors of child abuse, and so on, would all be swept within the language of the child porn law. And Kennedy points out that there's a couple of problems with this law. One is, as the court has decided previously, the government doesn't have to prove obscenity. These images do not have to be obscene, which means that they may well have serious literary, artistic, political value, and so on, like the movies, for example, clearly do. And yet one scene plucked out of the middle of the movie makes the whole movie a crime. And not only don't the materials have to be obscene, but there are no children involved in their production.